Right, well, good morning, everybody. Welcome to the latest in our series of Devereux Chambers Elevenses. Today, we're going to talk about the enforcement of foreign taxes in the UK. Inevitably, given the reciprocity in this field, we're going to touch upon the enforcement of UK taxes abroad. I'm Barrie Akin, and with me today are two other members of Devereux Chambers, Matthew Bignell and Colm Kelly. The format of today is straightforward. Colm, Matt and I will talk for approximately 45 minutes, and we'll have up to 15 minutes to answer your questions. It should be obvious on screen as to how to send in your questions. Shout, wave, do whatever you can if it isn't obvious. A particular reason for talking about this subject is that it's undergone significant change in a relatively short time, with quite a lot of recent development and not easy to find details. It's a mishmash. We have the common law position, which is still relevant in the absence of a bilateral or multilateral arrangement, because if there are such arrangements, they override the common law, of course. And as we'll see, there are such arrangements. We'll be talking about MARD, the Mutual Assistance and Recovery Directive, an EU arrangement, and the OECD Council of Europe Convention on Mutual Administrative Assistance in Tax Matters, not the snappiest of titles, and without an acronym. So since Colm and Matt are going to be talking about that, they'll have to find their own way of describing it without tongue twisting too much. So we need to look first at the common law position, and this is a recap of the basics. It's the obvious place to start, because in the absence of overlay from other arrangements, this is the law. And the general rule we can find in the authoritative textbook on the conflict of laws, Dicey, Morris and Collins, which says in Rule 3, English courts have no jurisdiction to entertain an action, one, for the enforcement, either directly or indirectly, of a penal or revenue or other public law of a foreign state, or two, founded upon an act of state. Well, we can forget about acts of state. Those of you who've studied constitutional law will remember that's all about people requisitioning hotels in Cyprus and burning them down and then saying, we don't have to pay you because it's an act of state. That's not relevant here. And equally, I think even though this isn't a statute, it's quite clear that penal, revenue and public all qualify the word law. So we have revenue law of a foreign state. So that would appear to be a very strong statement that foreign states' taxes are not enforced or recognised in the UK. The leading English case is the Government of India and Taylor. It's a decision of the House of Lords in 1955. Now, this was a claim for Indian income and capital gains taxes owed by an English company, the Delhi Electric Supply and Traction Company. The company was in liquidation. So this was not a case of the Indian government directly suing a taxpayer in England for a simple tax debt. Rather, it was a case of seeking to prove a debt in the liquidation of a UK incorporated company. Nor was it the case of the Indian government seeking the assistance of the British government to collect the tax, an area that both Matt and Colm will be dealing with shortly when we come to the international conventions. The liabilities in this case arose out of the sale of the company's business in March 1947 to the Indian government. I don't know whether that was a voluntary sale or not. The proceeds of that sale were remitted to the UK very shortly after the sale. In April 1947, so 1 month later, legislation was introduced in India imposing taxes on the sale or exchange or transfer of capital effected after the 31st of March 1946. So the liabilities appear to have been imposed retrospectively. So it wasn't a great case as regards the merits, but as for the law, the government of India duly lost this case at all levels. This wasn't the first time a foreign government's tax laws had been before the English courts, but it was the first time that the case had reached the House of Lords. In all the earlier cases going back into the 18th century, the courts had steadfastly refused to enforce or recognise foreign tax laws. And the House of Lords in Taylor had no difficulty in saying the same thing. Viscount Simmons quoted with approval the words of Mr. Justice Tomlin in a case called Re Fisher, Queen of Holland and Drucker. That's 1928. Actually, the full name is slightly bizarre. It's Re Fisher, Queen of Holland, a married woman, and Drucker, but there you go. And what was said in that case, which was approved in the House of Lords in Taylor, is this. My own opinion is that there's a well-recognized rule which has been enforced for at least 200 years or thereabouts, under which these courts will not collect the taxes of foreign states for the benefit of sovereigns of those foreign states. This is one of those actions which these courts will not entertain. Now, the House of Lords also denied the Indian government a backdoor approach. It held that proving in the liquidation of the UK company as a creditor of the company was not a possible exception to this rule, because the Indian tax wasn't a liability of the company in the liquidation, given that they just said that it wasn't enforceable in the UK. So in that case, they couldn't prove in the liquidation. Finally, on this case, there's one slightly amusing feature, which I think I must mention. One of the counsel who acted for the government of India was the great J.H.C. Morris, the Oxford Don, who by that time was the sole editor of what was, by 1955, called Dicey and Morris. So he was arguing that the rule set out in his own book, Rule 3, was wrong, or didn't mean what everyone thought it meant. It didn't go well. Anyway, I'm going to mention one other case, which is a case which reached the Court of Appeal in 1998, called QRS1 APS and Fransen, a claim by a Danish company's liquidator for restitution from a former shareholder. The only creditor in the Danish in this Danish liquidation was the Danish government for approximately £4 million of tax debt. And the defendant, as I say, was the former shareholder who apparently triggered the liability. So this was an indirect attempt to collect foreign tax, and the Court of Appeal would have nothing to do with it. So again, foreign governments nil, taxpayers one. Now, Matt's going to deal with some more issues on the scope of the common law position in a moment, but I should mention that other common law jurisdictions have the same basic Taylor approach to the enforcement of foreign taxes. And I can give a few examples just at random. So the USA, Canada, Ireland, Australia, Singapore, Jersey, and South Africa, but there's a wrinkle to South Africa. In a very small number of very rare cases, the UK's normal double tax treaties with other countries actually contain a mutual enforcement article, which, of course, because our treaties are part of our domestic law, override the common law. So the UK South Africa one is Article 25A. It doesn't lay down a machinery for collection, it just says they'll do it ad hoc, basically. But you have to bear in mind that even if you have a common law country, there may be a treaty override, a bilateral override. And the rule is also a feature in civil law countries. It's usually expressed differently as not enforcing the public law of a foreign state, but we do have the same effective position that countries don't like enforcing other countries' tax debts as a matter of common law, civil law. Now, that's me done for this section, but Matt is going to take us a bit further forward on the question of the common law. So over to Matt.
Thank you, Barry. I want to start by examining how and when Rule 3 is engaged. So Rule 3 is rooted in the concept of sovereignty. It is engaged when one state seeks to assert its sovereign authority, for our purposes in the form of a revenue law, within the territory of another state. The point is that any such assertion is inimical to the concept of sovereignty. Our starting point must therefore be to characterize the relevant action. Is that action an attempt by one state to assert its revenue law within the territory of another? This question is a matter for domestic law. How foreign law regards the action is entirely irrelevant. This principle can be traced back to 1962 and the Scots case of Metal Industry Salvage Limited and owners of the St. Hull. A French trawler was, in that case, a French trawler was sold by order of the court. the French government claimed priority over a salvage company on the funds from that sale on the basis that the owners of the trawler had not paid compulsory contributions owed by the employers in respect of state schemes for health insurance and family benefits. The Court of Session, Outer House, determined that the claims of the French government could not be maintained since they were an attempt to enforce the revenue laws of the French state in the Scottish courts. Lord Cameron reasoned, what would be regarded as the enforcement of a revenue claim or an attempt to recover taxes under foreign law seems to me to depend not so much upon the form which the imposition takes or the object upon or in respect of which it is levied, but upon the substance of the claim as viewed by a Scottish court applying Scots law. Now, Rule 3 is not engaged by claims by states which are not attempts to assert its revenue law, but which could be brought by any private citizen in private law proceedings to recover damages for loss suffered as a result of a civil wrong. This bracket of claims includes patrimonial claims, which are claims in respect of rights in real or personal property to recover damages for losses suffered in respect of that property, or reparative claims. Those are private law claims where the object of the action is not the vindication of public justice, but reparation to one aggrieved. Now, as regards patrimonial claims, a useful illustration comes in the form of Embasogo and Logo Limited number 1. This concerned an appeal of the strikeout of a claim by the President of Equatorial Guinea and the Republic of Equatorial Guinea to recover damages for losses said to have arisen as a result of an attempted coup. The Court of Appeal dismissed the appeal on the basis that the alleged losses arose from the exercise of sovereign power, namely state defense decisions such as the costs of detaining and prosecuting suspects or of increased security, and therefore Rule 3 was engaged. However, the Court of Appeal considered that if the alleged coup had been successful and damage had been caused to buildings or other property owned by the claimants, a claim in tort to recover damages would have been justiciable in the courts of this country. They would have been exercising the right of any person to bring private law proceedings to recover damages for loss suffered as a result of a civil wrong. Now, in respect of reparative claims, the recent Court of Appeal case of Scatterfall, Ningen and Solo Capital Partners LLP is the go-to decision. SCAT are the Danish tax authority by way of background. The defendants, who are a mixture of foreign individuals and corporate entities, had claimed and received refunds from SCAT in respect of a tax on Danish companies, which they had never paid or been liable to pay. SCAT alleged that the defendants had induced it to pay those refunds, totaling some 1.44 billion, by fraudulent misrepresentation orchestrated principally through entities based in England. The Commercial Court dismissed SCAT's claims as offending against Rule 3. The Court of Appeal upheld SCAT's appeal against that decision on the basis that these were not claims to recover tax, but to recover monies which had been abstracted from SCAT's general funds by fraud. SCAT was therefore not asserting a sovereign right or seeking to vindicate a sovereign power in the territory of another state by bringing the claim, but merely seeking the restitution of monies out of which it had been defrauded in the same way as if it were a private citizen. The Court of Appeal said that claims by a state which fall outside Rule 3 are not limited to patrimonial claims, but extend to claims which could just as well be brought by a private citizen, where the object of the action is not the vindication of public justice, but reparation to one aggrieved. Hence my attribution of the moniker reparative claims to this particular bracket of claim. SCAT's claims were said to fall squarely within that bracket. Now, it's worth saying something about direct and indirect enforcement. Rule 3 applies to an action for the direct or indirect enforcement of a revenue law of a foreign state. Now, direct enforcement occurs when a foreign state seeks to obtain money or property or other relief in reliance on the foreign law in question. The leading case is Taylor, which Barrie has already covered in some depth. Indirect enforcement occurs when a foreign state or its nominee seeks a remedy which in form is not based on its revenue law, but in substance is designed to give that revenue law extraterritorial effect. A good example is when a foreign company in liquidation seeking to recover assets from one of its directors, which the liquidator, appointed at the instance of foreign revenue authorities, would only use to satisfy the foreign state's claim for unpaid taxes from the company. And that particular example is based on the fact pattern of a case called Buchanan Limited and McVeigh. That concludes my analysis of the common law position that operates in the absence of any overlay from statute or arrangements between states. The next task is to analyse what arrangements there are between the UK and other states for the enforcement of foreign taxes. Now, the obvious starting point for this is the European Council's Mutual Assistance Recovery Directive. This directive has applied between the UK and EU member states since the 1st of January 2012 and continues to apply today. Colm is going to talk to you about the specifics of that continued application shortly. But before that, I am going to run you through the key provisions of the Mutual Assistance Recovery Directive, MARD. Naturally, if you're going to be advising a client, you will want to review the full directive or perhaps even go to council on this. Now, the scope of MARD is set out under Article 2. MARD applies to claims relating to taxes and duties of any kind levied by or on behalf of a member state. These claims include administrative penalties, fines, fees, and costs, including interest incidental to recovery. Now, interestingly, compulsory social security contributions and associated fees are excluded, and these are covered by the EU Social Security Regulation. The exchange of information provisions in MARD are set out Article 5.1. At the request of one member state's tax authority, the tax authority of any other member state must provide any information which is foreseeably relevant to the requesting authority in the recovery of its claims. Now, for the purpose of providing that information, the requested authority must carry out any administrative inquiries necessary to obtain it. There are also provisions on the presence and assistance of officials from the applicant authority, that is foreign officials. So Article 7 sets out that an agreement may provide for foreign officials to be present during administrative inquiries and to assist domestic officials with court proceedings in that member state. The agreement may provide that foreign officials can interview individuals and examine records during the relevant administrative inquiries. Moving on to the recovery provisions of MARD, Article 10 reads that at the request of the applicant authority, the requested authority shall recover claims which are the subject of an instrument permitting enforcement in the applicant member state. Under Article 11, applicant authorities are generally prevented from making a request for recovery if and so long as the claim and or instrument permitting its enforcement in the applicant member state are contested in that member state. The applicant authority must attempt domestic recovery first unless there are obviously no assets to recover in the applicant state, or domestic recovery will not result in the full payment of the claim and the applicant authority has specific information that the person in question has assets in the requested state, or such recovery would involve disproportionate difficulty. The requirement for the requested authority to treat any claim, there is a requirement for the requested authority to treat any claim in respect of which a request for recovery has been made as if it were a domestic claim and use the same recovery powers as would be used for a domestic claim. Now, there are time limits set out for MARD. So under Article 18, there's no obligation on the requested authority to provide assistance in respect of claims which are more than 5 years old, dating from the due date of the claim in the applicant state to the date of the initial request for assistance. If the claim or the instrument permitting enforcement in the applicant state is contested, the 5-year period begins from the point at which it is established that the claim or instrument is no longer contested. There are similar provisions for postponed payments or payments by instalment plans. However, there is a long stop period of 10 years dating from the due date of the claim in the applicant state. Questions of limitation are governed solely by the laws in force in the applicant member state. There are also value limits to be aware of. The requested authority is not obliged to provide assistance if the claim is worth less than €1,500. And finally, in terms of cost provisions, in general, the requested state is obliged to seek to recover its own costs. There is a certain exception to that. The states give up any claim for reimbursement as between each other, but in specific circumstances, for example, when recovery concerns a very large amount, the states can agree specific reimbursement arrangements between each other. I will now hand over to Colm Kelly, who will provide further information on MARD and international arrangements.
Thanks, Matt, and good morning, everyone. So as Matt said, I'm going to do the tail end of what we're talking about on MARD and then move on to the OECD Convention. And on MARD, what I'm going to talk about is its continual application and Brexit. So what I'm going to start with are actually the implementing regulations for MARD, imaginatively named MARD regulations. For anyone who's a fan of brevity in legislative drafting, these may be the things for you to look at because they are brief but uninformative. They largely say the revenue is permitted to comply with Article X of MARD, or the revenue must or is obliged to comply with Article Y of MARD. The exception to that uninformative drafting approach is what is now contained in Regulation 1.5 as a consequence of Brexit, and you can see it on the screen, and it deals with the ongoing application of MARD now that we have left the European Union. And if you're reading through that, you can see that what it effectively tells you is if you want to know how MARD continues to apply and for how long, you need to go and look at Article 100 of the Withdrawal Agreement. So if you went and did that, you would find that Article 101 applies MARD. Now, I'm going to come on to talk about Northern Ireland. So all of this is rest of UK at the moment. So there are 4 categories of claims in respect of which MARD continues to apply. The first, claims relating to amounts that become due before the end of the transition period. So if you've got debts that predate the transition period ending, then MARD will continue to apply to them. And the next categories are to do with claims that straddle that period. So claims relating to transactions that took place before the end of the transition period, but where the amounts became due after the end of that period. And then we have 2 specific provisions contained in other articles of the Withdrawal Agreement, and they are to the VAT claims relating to dispatches of goods starting before the end of the transition period, but ending afterwards. Then we have excise duty claims relating to the movement of excise goods under duty suspension arrangements, where the movement started before the end of the transition period and ended afterwards. So all dealing with those awkward situations where something straddles that date. However, all of that is subject to a long stop date, 5 years from the end of the transition period. So after the 31st of December 2025, MARD will stop applying in the rest of the UK, even in respect of those categories. So if a foreign tax authority has not chased a debt in the UK, trying to enforce against UK assets by that point, at the moment it seems that MARD is going to stop applying and they will lose the ability to do it under that regulation that will come on to talk about the OECD Convention. Then, as ever, because of Brexit, we must talk about Northern Ireland and the protocol. So at the time of speaking, the protocol is still in effect, unless anyone would like to intervene and tell me something very dramatic has happened in the last 30 minutes or so. And it preserves MARD in its entirety for Northern Ireland, but in a limited way. The way it does that is via 2 articles. 1, Article 5, sub 4, and then 2, Article 8. Now, Article 5 is concerned with customs and movements of goods. Article 8 is concerned with the VAT and excise. And they preserve MARD by simply saying that it is one of the very long list of pieces of EU legislation which are contained in Annexes 2, which Article 5 refers to, and Article 3, which Annex 3, which Article 8 refers to, and their effect is preserved. Article 5 says that it is preserved with the limitations set out in the Annex. As it happens for MARD, there are no limitations. So one, I think, less likely reading of that is that MARD continues to apply just as it always has for Northern Ireland related claims. However, given that it is preserved twice in 2 different articles, it's, I think, far more likely, I think this is the received view, that it is only preserved in relation to the things those articles are concerned with. So MARD will continue to apply in respect of Northern Ireland, but for customs, VAT and excise related claims. It's not expressly spelled out. It's not an enormously clear piece of drafting, but that would seem to be the more sensible reading. But there are still wrinkles and interesting points of debate and discussion that might arise if you do have to deal with claims that relate to Northern Ireland, because both of those articles preserve MARD using the language that you see quoted there on the screen. So it continues to apply to and in the United Kingdom in respect of Northern Ireland. So it's interesting that it is not simply saying it continues to apply to and in Northern Ireland. It is the entirety of the UK, but in respect of Northern Ireland. So obviously one needs to demonstrate some kind of link to Northern Ireland. If you had assets situated in Northern Ireland, that would seem like a fairly straightforward scenario. In the same way that prior to leaving the European Union, a EU member state could enforce against assets that were located in the UK. Straightforward to say these assets are now in Northern Ireland. It is somehow related to VAT, customs or excise. We should be able to enforce there. But how weak does the link have to get before it is no longer in respect of Northern Ireland? If you had a situation where there was a taxpayer who was resident in Northern Ireland but held assets in the rest of the UK, would that be a sufficiently strong link for an EU state to make a claim in the next number of years to the revenue, and for the revenue to enforce that claim against assets that were held outside of Northern Ireland? It's not clear. I've looked in the revenues manuals and I can't find an answer to it there. Perhaps one of you can, because they are more difficult to navigate than normal by virtue of the almost Soviet levels of redaction and information that's withheld from them for fairly understandable reasons, I expect. And in any event, all of these questions may end up becoming purely academic, given the current mood music in respect to the protocol. So let's come on to the other option for international enforcement, the OECD Council of Europe Convention on Mutual Administrative Assistance in Tax Matters. I'm going to take this fairly quickly because it replicates many of the obligations that you've seen in MARD and are now familiar to you. So it's an 88 convention amended by a 2010 protocol. The UK has been in it since 2008. And it is in force in almost all of the 144 signatory states, but, and this is a point I'm going to keep coming back to, you have to look at the reservations because they can be very, very significant. And that is relevant at the very earliest stage when we look at the taxes covered, because there are two categories of taxes. The first, in respect of which you cannot make a reservation that will mean you can never render any assistance, the non-reservable taxes, taxes on income and profits, capital gains and wealth. There is then a second category of taxes in respect of which, if you wish, you can enter a reservation and you will never have to render any assistance whatsoever in respect of those. And those are listed there. Two are kind of not quite taxes, but well, first is not a tax, but the person who imposed the tax. Taxes imposed by political subdivisions or local authorities. And then compulsory social security contributions. Those are common opt-outs. And then there are a list of other specific taxes. Some states have them, some states don't. So estate taxes, inheritance tax, things like VAT, excise, taxes on motor vehicles. There's also a residual category of all of those taxes, but only insofar as they are imposed by a political subdivision or local authority, because you might be happy with a state tax imposed at the central government level, but not like an estate tax imposed by a local authority. So you can reserve away all of those. You can't reserve away the first three. Then coming on to the powers, requests for information. This can't be opted out of. You're obliged to provide any information, in particular as provided in this section, that is foreseeably relevant for the administration or enforcement of the domestic laws concerning taxes covered by this convention. And clarifying how far that obligation goes, it is an obligation to take all relevant measures to provide the applicant state with the information requested, if the information is not in the tax files of the requested state. So if HMRC get a request, it's not enough for them to simply say, well, we don't have it, so therefore that's the end of our obligation. They have to take all relevant measures. There's also specific provision saying it is not an excuse or a way out of that to simply say the information is held by a bank or a financial institution. There is also an obligation in some cases to spontaneously provide information without being requested. So you have to provide information if one state is aware of a tax loss in another state, or if it becomes aware of a reduction or exemption from tax in the first state that would lead to a corresponding increase in tax in the other state. And there are many other examples listed in Article 7. Of course, you'll want to look at this if you're advising on it, or of course, always come to council. Then tax examinations, they're called examinations here rather than investigations. So these can happen. So Article 9, the requested state may permit the applicant state's representative to be present in the territory, but what it lacks is any specific provision, akin to what we've seen in MARD, that contemplates the representatives of the applicant state conducting interviews or examining records. It's not ruled out, but not specifically contemplated. Then the big one, recovery. Article 11, at the request of the applicant state, the requested state shall, subject to provisions of Article 14 and 15, take the necessary steps to recover tax claims of the first mentioned state as if they were its own tax claims. And that's the powerful part of that article. You have to treat foreign tax claims in the same way you would treat your own. That's potentially a very expansive obligation to place on someone, but Of course, if you can simply enter a reservation saying, I won't do it anyway, then it's quite easy to become one of the nearly 144 countries that have signed up and purport to have this in force. Then you can also have situations where the requested state will allow payments to be deferred or payments to be made in installments. Barrie will talk a little bit about that when he's talking about practical information. There are a few other matters, time limits. So broadly speaking, the limitation for tax debts are governed by the laws of the applicant state, but any extension of time provisions that exist in the requested state will apply and are treated as if they apply in the laws of the applicant state. So it's a hybrid. There's a 15-year long stop, so longer than MARD. There are limited circumstances listed in Article 21 in which requests can be declined. And again, you should go and look at the full list there if you're concerned with this. To give you a few examples, if there was a situation where the request would require the requested state to discriminate against a national of the requested state compared to an applicant state, then they can turn it down. Similarly, they can decline in a situation where the applicant state has not pursued all reasonable measures under its own laws. Then costs, the usual situation is that the requested state bears ordinary costs and the applicant state bears extraordinary costs. No assistance given there what extraordinary means compared with ordinary, what Colm and all the lawyers could have dealing with that. If you want to find out where this is implemented, you'll find it in the recovery of foreign taxes regulations. I'm not going to go through all of them. They largely replicate what's in the treaty. Just want to look at a few of them. First, Regulation 3, emphasizing the point about collection is you have to treat, the revenue is to treat foreign tax claims as if they were a domestic tax claim for income tax, and they are permitted to take any enforcement action that the revenue could take in respect of a domestic income tax claim. So all the familiar ways of enforcement. The request has to be made in writing and expressed in the pound sterling equivalent of the value of the tax debt, not in the domestic currency. And the convention tells you how you should go about converting that on what date by reference to an exchange rate at what relevant exchange. And then Regulation 6, the revenue isn't allowed to question the person's liability in a foreign tax claim unless they are in one of these three circumstances. Regulation 9, that the applicant state notifies the revenue that the debt has been satisfied or is cancelled. Regulation 10, if the person in question can show that proceedings relevant to the liability are pending or about to be initiated in the foreign territory, and Barrie will talk a bit about that, disputing the foreign tax debt. And then finally, Regulation 11, the end of the road where the court in the foreign territory has determined the claim in the person's favour. Now, reservations are the important, perhaps the most important part of this. Article 30 allows signatory states to make reservations in respect of all of the obligations apart from the obligation to exchange and provide information. So you can reserve away the obligation for recovery. There is also a minor obligation to look at to allow the applicant state to get the assistance of the requested state serving documents related to the debt. That again, you could enter a reservation in respect of. And as I've said, in respect of all of the kind of optional category of taxes, you can reserve away any obligation to provide any assistance whatsoever. So even information exchange can be reserved away for those. There are then mutuality provisions in Article 30, so that if you have entered a reservation in respect of something, you cannot require another signatory state to enforce in respect of that thing. So if you say, I'm not going to do any recovery, you can't insist on another signatory state for recovering something from you. So if we look at the position for the UK and its territories, we'll see UK itself is happy with recovery and service of documents. And apart from taxes imposed by political subdivisions and local authorities and compulsory social security, it will also give you all the help you want in respect of that other category of taxes. At the opposite end of the spectrum, we have Bermuda, Gibraltar, Guernsey, the Isle of Man, and Jersey, all very reluctant to give you any assistance whatsoever. And then we have hybrids somewhere between, where BVI is happy with providing you with assistance on the service of documents or assistance concerning compulsory social security or removable property, but not other kinds of taxes. Sometimes it's because in that jurisdiction, they don't have those kind of taxes. They simply want to be reciprocal. I've taken a selection of other signatories to see how varied the situation is abroad. So, for instance, Canada is fairly absolutist, saying no, 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 no. And of course, I've miscolored two things. It is happy with VAT and excise. Despite being red, should in fact be green. It's a little Y is there. Other countries are all yes. France is very enthusiastic, as is India. Other countries, it's more mixed. Luxembourg is an entirely no, and that may not surprise many of you. And for some of them, you'll see I have yes/no, and it's colored in an orange. And that is because, as with many things in international treaties concerning tax, there are lots of details, there are lots of footnotes, there are lots of asterisks. So before advising on this, either come to council or go and look at the very long list of reservations, which you will find on the Council of Europe's website, and is fascinating reading if this is indeed the kind of thing that you find fascinating. So with that said, I'm going to hand back to Barrie, who's going to talk to you about what you're probably all actually here to hear about, which is practical information, how to deal with the enforcement of tax debts. So Barrie, over to you.
Right, sorry, I'm now back live. Yes, I think there's a couple of things that I'd like to explore here. One is the actual procedure which HMRC used in enforcing under both MARD and the OECD Council of Europe Treaty. In fact, HMRC don't actually distinguish between the two in their manuals, even though there are some small differences between the two in terms of time limits and so on. What happens is that HMRC will have received something called a WIPI, a Uniform Instrument Permitting Enforcement. That will come from the Foreign Tax Authority, and as we've already heard, there's a limited discretion not to enforce debts under MARD. For example, debts below €1,500, including interest and costs, or where we have stale claims. And so under MARD, it's 5 years since the debt became due. So the WIPI goes to an international debt unit within HMRC, which takes up the cudgels on behalf of the foreign authority. And if payment is not received after the first attempt, then the international debt unit pushes the claim through the usual HMRC enforcement channels, with obviously the risk for the debtor of additional costs of collection and enforcement. The debt is converted to sterling, as we've already heard. So interest on late payment on that now sterling tax debt is levied by HMRC at the HMRC usual rate. If, and that's an appropriate if it's a tax debt on which HMRC would charge interest if it were a UK tax debt. There are some exceptions to interest charges in our legislation. In terms of things like time to pay, the basic rule is that you use similar criteria to those in domestic taxes, but only with some degree of consultation with the Foreign Tax Authority. So the way it tends to work is the Foreign Tax Authority, when submitting the WIPI, can say, yes, you HMRC can negotiate time to pay, or it says you can't, or it says you can if you come back and consult with us. There are three options, and whichever one of those is ticked, HMRC will follow that. There's also the question of contested debts. As you've already heard, effectively recovery is suspended when either the Foreign Tax Authority or the taxpayer, well, I should say the debtor, potential debtor, says that the debt is being contested or is about to be contested. But HMRC will only suspend collection if the putative debtor has followed the correct dispute procedure. If they haven't, and the procedure is laid out, then HMRC will not suspend collection. Crucially, HMRC are not concerned in adjudicating a foreign tax dispute. They will check with the applicant country on the status of any dispute, and in effect, what the individual has to do, the individual debtor, is to take up any dispute with the Foreign Tax Authority. HMRC are not interested in doing that themselves. As we've already heard, MARD is due to expire on the 31st of December. There are likely to be quite a lot of MARD-related claims right up to the deadline. But as we've already heard, debts that are more than 5 years old won't actually have to be collected. Now, this brings me to an area that I think most practitioners experience at some time in their careers. The client who asks, where can I put my money, or where can I live without fear of pursuit by HMRC? In other words, UK people who think they might want to go abroad. I think it's important for an advisor to tread quite carefully here. There's a variety of possible circumstances, and I think one's degree of caution probably varies quite widely. One that I came across was an individual who had been UK resident, but who'd left the UK some years before, but had potentially incurred substantial UK tax liabilities after leaving. It was related to the exercise of share options granted whilst resident, but actually triggered when non-resident. And there's a serious technical difference of opinion with HMRC as to whether there was a liability, and there was a prospect of settling and not going through the system. Crucially, he had no assets left in the UK, and he lived in a territory that had signed up to the OECD Council of Europe Treaty, haven't they all, but had reserved out of enforcement. His assets by this time were split between that jurisdiction and another jurisdiction that had also reserved out of mutual enforcement. So I didn't have any difficulty in simply confirming the technical position to him as regards HMRC's ability or inability to collect. This was weaponized slightly. It was subtly trailed in front of HMRC during the conduct of the dispute that they might find difficulty in collecting, but it was not said, of course, that he would not pay. HMRC do not give in to that kind of blackmail in my experience, and they didn't in this case either. So, but at the other end of the scale, you get the client who's got a clear UK tax liability, not fully declared, so there's no issue there, but decides that he wants to up sticks and live elsewhere without paying, and says, well, where's best? That causes me more concern. Declaring a liability but failing to pay it is usually regarded as an entirely civil matter in the UK tax system. It's dealt with by charges to interest, late payment penalties, but it's not, as I see it, more than that. I'm not a criminal lawyer, and I wouldn't be confident as to where the precise boundary might lie. And one of the things which gives me cause to be concerned here is Section 106A of the Taxes and Management Act. That created the offence of fraudulent evasion of income tax, and we have it on screen. A person commits an offence if that person is knowingly concerned in a fraudulent evasion of income tax by that or any other person. It goes on a bit further, but that's all we need to look at. I think this section was introduced as a result of the Grabiner Review, which the Labour government started in the early years. It's Blair premiership. And presumably it was introduced to cover a perceived gap in the law. Now, since the state had been successfully prosecuting for cheating the public revenue or conspiracy to cheat the public revenue for many years, I'm not quite sure what that gap is. Maybe it's because this offence is triable either in the Magistrates' Court or the Crown Court. Maybe it was thought that introduced a slightly more streamlined procedure. But the wording does beg a question. What does being knowingly concerned in the fraudulent evasion of income tax actually mean? It can clearly apply to advisors who are knowingly concerned. But in my view, it should only apply where there has been dishonesty and the person is knowingly involved in that dishonesty. After all, fraudulent behaviour does require dishonesty. And there are a couple of cases that have got to the Court of Appeal Criminal Division on this, and dishonesty has certainly been a requirement. It's quite clear that you can't just be reckless. But what we don't have is anything where the revenue or the revenue's prosecuting authority has tried to say that knowingly not wanting to pay is fraudulent. For me, I think the jury is slightly out on that. The answer, I think, should be no. but the hair that I'm raising it isn't covered in any binding authority. I'd rather, I think, have a detailed answer from a criminal practitioner, so I would tread carefully in this kind of situation. Having said that, there are provisions in Schedule 38 of the Finance Act 2012. I'm not putting a slide up for this. They replaced the old Section 99 of the Taxes Management Act, the advisor's nightmare, dealing with dishonest conduct by tax agents, which bring about a loss of tax revenue. I'm not, so as I say, I'm not putting it on screen. I'd merely say that it doesn't bring the kind of non-payment we're contemplating within its ambit at all. So that's a straw in the wind in the right direction. But nevertheless, I do think that discretion is advised if the client wants advice on the best way to do a bunk and put his or her assets beyond HMRC's reach. So you've been warned. That's all I wanted to say. And before we go to Q&A, Matt, Colm, is there anything you'd like to add?
Nothing from me.
Nothing from me.
Okay. Now, the magic of this system is probably beyond me. So I now need to see if we have some Q&As on here, and we don't. Right. Well, in that case, well, I'll give it a few seconds in case anybody is desperate to pose a last-minute question. But if not, I think we're done. So, Matt, Colm, you have nothing to add?
No, I think we'll just take that as a re-endorsement of how comprehensive and informative our presentation was. But
Well,
yeah, still nothing coming in now, so I think we can probably say good morning to everyone.
Well, in that case, yes, can I thank you for being a patient and hopefully attentive audience, and hopefully we'll be having another one of these Elevenses in the near future, and if we do, we will be informing everybody in the usual way. So thank you.